data, and then we are going to produce some of the things that that definitely says completely different. In the first statement, in a couple of statements, the Charlie from the State Department said very clearly that he moves the dates so that the numbers will be used anywhere between 6 months to 12 months. That's what he said. Now, when you look into the USCIS, though, the USCIS says that they take anywhere between 13 months to 50 months to adjudicate the application. Now, this is not the statement that I'm making. Paige, can you put the slide on? So this is not the statement that I am making, guys. This is what the data that is coming out from the USCIS website. According to their website, that the processing time for USCIS is, in this particular thing, it's Texas Service Center. There are other service centers that are 13 months. So somewhere between 19 months and 50 months. This is taken today from that is July 20th of 2021 from the website of the USCIS. They are telling it takes 19 months to 50 months for the employment-based adjustment of status applications to adjudicate. So if your adjustment of status application has been filed only before May 26, 2017, you can request the USCIS saying that, hey, it's been too late. You haven't adjudicated the application. Believe me, there are applications that are pending from 2012 we filed in that are still not adjudicated. We keep raising service requests. In those cases, we can raise a service request. When the State Department is moving the dates, I mean, what are they looking at? What data they are looking at? Can you go to the next slide? When you look into the stats, though, when you look into the data, though, in September 2020, at the time when the priority dates were being moved, only 118,000 applications are pending, though. So if the State Department wanted these applications to be adjudicated in the year of 2021, starting from October 1st, they should not have moved the priority dates in October. They should have moved way earlier. Now, we know that COVID is affecting. We know the consulate got affected. We know the family-based visas are coming into the employment-based. We know that these things are going to fall into it. We may not accurately expect that it's going to be 120,000, 130,000, or 100,000, but the dates should have made much before, so that we should not have wasted this 100,000 extra green card, though. Now, when did they move the dates? They moved the dates on October 1st of 2020. Now, according to the data, the previous slide, what it says that the USCIS is taking 19 months to 15 months to adjudicate the applications. Believe me, guys, there are a lot of people who filed adjustment of status along with the EAD application in EAD applications in October. Their EAD is not approved. What is the State Department thinking about? Let's go to the next slide. So if you look into the first quarter of the 2020, that is from October 1st to December 31st of 2020, still the number of applications that are pending are only 176,000 applications in the 485 application. So in other words, still the USCIS could not open the packages that we filed in October and November. Still the State Department has not moved the dates. How do we expect next year? Now, we did a mistake this year. We may lose up to 100,000 green cards at this point of time. Are we in a shape to next year where we can utilize the 140,000? He won't move the final action dates. He won't move the filing dates. How do we expect next year? If you want them, you should have moved them in June. You should have moved them in May. All along, State Department has been telling that it's going to be anywhere between 130,000 to 160,000 extra green cards that will be coming into 2022 starting from October. But yet, he does not move these things. He thinks that these things will be adjudicated in 3 to 6 months. That's what he planned. But the USCIS says, no, it's between 19 months to 50 months. So even if he moves all the dates on October 1st, no, they cannot adjudicate these applications by October of 2022. There'll be a lot of wastage of these applications. So if you go to the next thing, what Charlie has said was that in October of 2000, go to the next slide. Go to the next slide. Look at this. In January 1st to March 31st of 2021, the data shows that it's 273 applications pending. So in 273 applications pending until March 31st of 2021. Now, the applications received in this quarter between January and March of 2021 is 117,000 applications. Look at the magic number, guys. The previous quarter, it was 87,000. This quarter, it is 117,000. However, if you look into it, the priority dates moved backward in January, but yet there are more applications received in January. Why is that? The reason is that when we filed the application in October and November of 2020, the USCIS could not even open and give us the receipt notices until after January of 2021. They took 3 to 5 months to issue a receipt notices for these things. What Charlie is telling is that they are going to adjudicate in 6 months? Really? I mean, come on, State Department. Be proactive. Try to move the priority dates much faster so that next year the wastage is not going to be there. Now, I'm going to go and show you a plan where we can still, right now we are in July of 2021, we can still get these things done in this year. We can still get these things done in this year. I will show you the July 2021 visa bulletin that shows that July 2007 visa bulletin, exactly what happened in July 2027 bulletin was, in July 2007, the entire priority dates, this is approximately 14 years, guys, ago, okay? And right now, the reason I'm telling this thing is that even though it's a little bit late, we still have time to recover the green cards. My advice to the State Department is, look what was being done in 2007. For the July visa bulletin, everything was made current. This happened in June 3rd week, somewhere around that time. All the priority date except the other workers are current. EB1 is current, EB2 is current, EB3 is current, EB4 is current, religious visa is current, FI is current, target employment areas is current. Everything is current except the other workers. This happened. The reason this happened at this point of time, Charlie said it yesterday, that in 2007, there were not enough number of 485 applications that were in the pipeline to adjudicate the applications for the 485. That's the reason he made everything current. I'm not sure if that is true. Look at the next slide, guys, that shows that in July of 2007, in the same month, on July of 2007, what happened on July 2nd of 2007, this is the first Monday. July 1st was a Sunday, July 2nd was Monday. What did they said is that, whoa, they already approved 60,000 green cards in the past 1 month, so we are taking the dates back. Wait a minute. In June 16th, everything was current, but we could not file it until July 1st. By July 1st, That means only in 16 days, let's take them as what they made a statement of past 1 month. In 1 month, they adjudicated 60,000 applications. And they said, no, we're going to put the dates back. My request to the State Department is that USCIS has a lot to lose if you make the dates current for everybody. If you make the dates current, they are going to use all the green cards that are available. It is the duty of the State Department to make sure that all numbers are being used. And we have seen historically that when State Department did this kind of activity in 2007, 60,000 green cards were being granted in 1 month. This is a statement. I am not making this statement out, guys. There are links that are provided in these things. All this data is coming from the State Department. All this data is coming from the USCIS, not from our website. Look at it. July 2007, on July 2nd of 2007, we are going to reject all your 485 applications that you filed because USCIS has already granted 60,000 green cards in the past 1 month. My suggestion is that even though August Visa Bulletin has been passed, you can still change the August Visa Bulletin. You can still make it current so that the USCIS will adjudicate the applications. Then we don't have to waste the 100,000 green card that you have been telling. Now let's go to the next slide. I will show you in the August Visa Bulletin. What did they do in the August Visa Bulletin? In the August Visa Bulletin, though, everything is unavailable. Why? This is August 2007 Visa Bulletin. Now you may not, this looks like dream to you guys. How come it was current, it was back, it was not current? Well, look at it. On August 2007, EB1 is unavailable, EB2 is unavailable, EB3 is unavailable. Unavailable means practically at the end of the year, nothing is available. What happened? They gave the green cards to all the people who are eligible for, so they removed all those things. They completed, in that time it was only 140,000 green cards. Now the USCIS can do it if the State Department has the courage to move the priority date as it did in 2007. The number of green cards that they are telling that 100,000 green cards will be wasted will not be wasted if the August Visa Bulletin has been reversed and made it current. If not, at least even if you make everything current in September Visa Bulletin, then still USCIS is going to act on it, is going to act. Even if you threaten that you're going to make it current, the State Department threatens USCIS, look, it is my responsibility to give the green card. If you don't, I have to make this current. If they do it, at least they will move to a very significant amount so that the wastage is less. Now, this is a fiasco that happened in 2007. A lot of the people were being able to file the adjustment of status at that point of time. They benefited to that thing. This is what it says. July, everything was current. August, everything was unavailable. Now, there was because of all this fiasco, though, at that point of time, the Congresswoman Joy Lofgren stood by our side, where what they did was that she took the charge. In July 11th, she wrote a letter asking USCIS and State Department to give all the notes, all the discussions, what happened, what's the reason why the priority dates when they moved, why did they move it back, and because of Congresswoman Ms. Lofgren from San Jose area, we are allowed to file adjustment of status even though July Visa Bulletin was been reverted, even though August Visa Bulletin was unavailable. All the way, we were allowed to file 485 applications, everything current until August 16th of 2007. There is a Telegram group in there, just like WhatsApp group, that is there in San Jose that is trying to meet Congresswoman Joe Lofgren. I put a link there. If anybody wants, you guys, any of you guys want to join that group, it would be better that you join. Please note that I have given the links for all what I discussed. These are all government websites. I've even given link for Joe Lofgren's website where she posted this letter, what she wrote in 2007. I've also given links for the visa bulletin. I've given links for the processing times. Please check those things, verify those things. Anything that you want to speak on this one, Rebecca?
Yeah, so obviously with the way that the I-485 processing times are posted on the USCIS website currently, it seems unrealistic maybe right now for the number of applications that are still pending to be adjudicated within this remaining months of the fiscal year without any wastage. But like we just saw from the numbers in 2007, it is possible USCIS within a month adjudicated 60,000 I-485 applications. So it's not unprecedented. It's been done when forced to, when required to, when put on the spot. USCIS can and has done this in the past. It's not something new. And so how, maybe what are some ways that could expedite some of the I-485 processing right now? So there are still a number of applications filed last fall that are still pending right now. You know, USCIS, under this new administration, it can get creative on how to process these remaining applications without wasting these immigrant visa numbers. Some things that it can do are maybe reusing the biometric information. There are numbers of I-539 applicants in the past 2 years who have had to go in to have their fingerprints taken. A number of them probably also filed I-485 applications. If their biometric information can be reused for this application so that they don't have to be scheduled, that would remove one huge hurdle. Another proposition is to stop sending RFEs for the missing medical exams and to just have it submitted later. Go ahead and approve the I-485 with the submission of the medical exam later. Another proposition is maybe using the I-485 receipt notice as work authorization and advance parole as the travel document, so that you're not using USCIS resources to process I-765 and I-131 applications, to put those resources to use to process I-485 applications. You know, it's the I-485 application the requirements haven't changed that much since 2007. There were additional hurdles put in place by the previous administration, such as the in-person interview requirement and the I-944 form that required all the public charge financial data. But that requirement, the I-944 form, is no longer a part of the AOS package. The in-person interviews, for the most part, are not being required anymore as a result of the pandemic the past year. And so, you know, what are the extra things really that exist now that prevent USCIS from adjudicating the number of applications that it has to?
There are some drastic checks, Rebecca, other than, you know, if they do 60,000 or 90,000 per month, which they can do. They can also have, they have the ability that on September 30th, they can approve the green cards for all the people, and they can revoke the green cards on October 1st. In that way, those green cards will be carried to the next year. Those green cards will not be wasted. They have the provision in the law that allows them to do it. So if the administration wanted, they can do it. So it'll be upon you guys to put a pressure on the USCIS to make sure that these things are done. It's up to you guys to contact the congressmen to make sure that these provisions are being taken care of. So if you contact your congressman, you would be able to get all these things taken care of it. I would advise all the people to contact the congressman. We have provided the draft letters at the bottom so that you can look into those draft letters to send it to the congressman. Anything else, Rebecca, before we go into question and answers, though?
No, not right now.
The question that for all the links that we have provided at the bottom of the for all the links that we provided at the bottom, we recommend that we want you to go to we want you to take advantage of these links that we have provided. And when you're at the links that we have provided, please use them. Please write letters to the USCIS. Please verify the information. What I said, is that true or not? Is it something that is that something I made up or not? I provide the links at the bottom of those things. Please look into those things and contact your congressman. Let's go to the question and answers for those people. A question that came from Funny Kumar from YouTube is that, am I allowed to travel outside the USA while I-485 is pending? Funny, yes, you can travel, assuming that if you're an L1 or H1B, if you have the stamping already done, you can definitely travel outside the country. If you don't have the stamping, if you have an advance parole, you can still travel. Now, either way you can travel, but please note that you may be subject to the travel ban. If you are subject to the travel ban, then you must be having an exemption. Either you have a child who is born in United States, or if you have the visa or advance parole, you have to stay outside of India, if you're traveling to India, for more than 14 days before you enter the United States. There's a little bit correction that I want to note down, that in the last week that we said that advance parole people can travel, but there's a little bit change in that they can travel, but they must either have children born in United States, otherwise they will have to wait for 14 days before they come into United States.
Harinath from YouTube is asking about the H-4 EADs, whether they are being adjudicated with H-1Bs now. So unfortunately, we have been keeping an eye on H-1Bs filed concurrently with the H-4 and EAD, especially since May, when the biometric requirement was no longer needed for I-539 applicants. Unfortunately, it looks like that removal of the biometric requirement for I-539s has not speeded up the H-4 and EAD processing. So far, we're still seeing that H-1Bs are being approved in, if it was filed in premium processing, it's being approved within 2 weeks, but the I-539 and I-765 continue to be pending. And yeah, we'll just need to wait on USCIS to see how they're going to improve those processing times as well. Their last statement on that was that they were hoping that by this fall, that processing time would be down to 6 months.
Questions are coming with regards to a lot of people have filed the 485 application in October of 2020. They still did not receive the EAD or advance approval. Unfortunately, that's been, for most of the cases, there is not much that can be done at this point of time. Questions are coming with regards to the EB1 cases delay. Yes, we have seen some improvement on the EB1 cases though, but yeah, USCIS is much slower right now comparatively. Previously, EB1s were, the only people who were current. Now there are too many people who are current, so your chance may not be coming as fast as in a normal year circumstances. So yes, we have seen that. We have seen that a lot this year, though. The previously, what EB1 used to take less than 6 months, but now a good number of the EB1 cases that where the I-140 is approved is taking more than 6 months to get the 485 approved.
Rahul Sharma has a question about what if his priority date becomes current while his perm is still in process with the Department of Labor? Is he required to apply within 1 year of his date becoming current? So it sounds like Rahul is familiar with the rule that for H-1B extensions beyond the 6th year based on an approved I-140, if your priority date is current according to the final action dates chart, you're actually only eligible for a 1-year H-1B extension based on that I-140 approval instead of the normal 3-year extension that we're used to. However, in your case, If your perm is still in process and your priority date is current based on an I-140 from an employer that you are no longer with or who no longer has that job offer for you, that requirement doesn't apply to you. You cannot file an I-485 application until you have an I-140 filed for you, and you can't do that until your perm is approved. So in your case, you would just need to wait for your perm to be approved, then the I-140, file the I-140 and I-485, hopefully at the time that the priority date is still current when the perm is approved. If you do need to file for an H-1B extension during that time, I would include an explanation of that in the H-1B application, stating that although you have an I-140 approval that has a current priority date, that job offer is no longer there, either because you're not working for that company or the company withdrew that job offer.
With regards to the prediction in October 2021 for EB2 and EB3 though, Charlie has said that the final action dates are not expected to move drastically. Now, even if you look into October of 2020 though, the final action dates did not move drastically. It was only the filing dates that moved very drastically though. Which is surprising. I don't know why he didn't move it, but he should have moved both the things. He repeatedly said again that the final action dates are not expected to move significantly in October. But when it comes to the filing dates though, he was a bit vague every time the questions were being asked. He said, I'm going to consult the USCIS, I'm going to look into the data. I don't know what data he's looking at. The data is there available. If you look into the amount of applications pending right now, it's only 268,485 applications pending. They're not enough. Even if you give the green cards to all the people, they're not enough to give the green card next year. So he should have moved the dates right now. What I believe in, that what we should target to request Charlie is to address the employment-based green cards and family-based green cards separately though. In the family-based green cards, more than 90% of the green cards are processed by the consulates. The green cards are given at the consulate. When it comes to the state, when it comes to the 485 though, when it comes to the employment-based green cards, so more than 95% of the applications are processed here. The timeline for USCIS is quite different than that of the State Department where the consulates are. Now, don't try to rush guys right now to try to go to consulate. Now it still is a big problem because you still need to file an I-824, which is going to take approximately 2 years, plus the time. That's going to be very bad thing to do it instead of doing the 485 year. If your priority date is current, it will be better that you file a 485 for most of the people though. But I think so that the family immigration and the business immigration should be segregated separately, should be addressed separately, should be taken up separately. Processing times and the dates movement should be differently done than that of the business, family immigration.
Srinivas from Facebook is asking, when is he eligible to change employers after his I-140 petition is approved? I assume that it was filed last year with an I-485 application concurrently. So it's not, you don't have to wait 6 months from the I-140 approval. So AC-21 requires that your I-485 application have been pending for at least 180 days. So if your I-485 was filed last October or November with a downgrade I-140, then you are eligible under AC-21 to change employers, and for that portability, your new employer, we recommend that they file the J supplement. The reason why we recommend that the waiting until the I-140 is approved is so that you don't need to show USCIS that the I-140 was approvable at the time of filing. So if the I-140 is approved and there isn't any risk anymore of it being denied, so that your I-485 would be denied. Once your I-140 is approved, and your I-485 has been pending for at least 180 days, it's fine to change jobs based on AC-21.
Nick is asking question, H4 EAD lost job, can we apply for unemployment benefits? Yeah, you definitely, if your EAD is still valid, you are eligible for the unemployment benefit. Questions are asking with regards to the rejection of the filings. Yes, if you're filing right now, that was been rejected in October. For a while, they did accept it depending on the reason for the rejection. Especially if there is something about the form has not been filled properly, they definitely took it. But if there is any problem with the checks or so, they definitely are not accepting again.
There was a question about where to send a medical exam if you are trying to interfile it. So we do have an article on our website about exactly how to interfile your medical exam. In general, it should be sent to the service center where your I-485 application is pending, not your I-140.
Francis Chima is asking, where are the sample, he's looking for the sample letters to write to the congressman, the local congressman and also Congresswoman Joey Lofgren. It's there at the link at the bottom of the video. If you scroll down to show more, you will find those things. Now, when last 2-3 sessions though, we did send the drafts to write to the State Department. Thank you for all the people who wrote it. Looks like 2/3 of the emails that the State Department have received because of the format that we have provided. They did comment on the format that they are copy and paste, but definitely these are the things that are hurting us. You know, these matters when people are copying, it's their matters. We are expressing, we're giving them ideas to ask them the proper questions to the State Department. All these people who have sent, they're really personally affected by this visa bulletin backlog. So I don't see anything wrong in people sending the emails that are really affected and that want answers to those things. If you look into the questions that have been asked, there are only like 16 questions that have been allowed to answer, and they will take the majority of the questions that were been asked by the majority. That's what they have given a criteria, and that's what. In that, people are asking question about pending legislation to the State Department official. They're not supposed to comment on that. They're not supposed to take one side or the other. As an official figure from the State Department, they cannot do that. These are the questions. When we draft the things, though, we're piercing to the direct questions that will affect it. Nothing wrong with it. Please be watchful. In our next videos, we're going to come with next set of questions for the State Department, why they're not making current and showing the data. In the meantime, I want you to contact the congressman. It's very hard. We are practitioners. We see people, aged out kids, when they call and they say, hey, how come my friend is getting the green card, I'm not getting the green card? My answer is, I asked that lady girl, where is your friend's family from? Oh, they are from England. Well, because they are from England, they get the green card. Is that how you speak? Is that not discrimination? You're a lawyer, you speak like that? Well, you know, I'm sorry, but that's what it is. And then they say, oh, well, you know, I can't take this internship because I am on H4 visa. What should I do? Well, you can't take the internship. And they say, why? How come that person, their parents are illegal and they are illegal, they got the employment authorization, why can't you get? What would I answer this person? Your parents did a bad job.
Let's see, Ram from YouTube is asking, what is the general time frame between the EAD and green card approval? So there isn't a set time frame between the EAD and green card processing. So the EAD is not actually a required step in getting the green card approval. So what you do need to have your I-485 approved is the immigrant petition. So your I-140 needs to be approved. You need to have submitted your fingerprints and medical exam, and your priority date needs to be current according to the final action dates chart. So it's not a requirement that the EAD be approved before your green card gets approved. I've actually had some clients get their green card approved before their EAD was issued. So it depends a lot on your priority date, on those other factors, the fingerprint notice, fingerprint appointment, and whether you've submitted your medical exams. EADs in general are just extremely backlogged. The ones that were filed last year for the I-485s, I would say the majority of them are still waiting for the EAD and AP card to be approved.
The dates being current, you want to take people are asking about, you want to go?
Okay, so let me see. So we have a question on whether USCIS is consciously rejecting I-485s filed concurrently with an EB3 downgrade. We are not aware of any conscious rejection of I-485s with EB3 downgrades. There were a number of rejected I-485 applications last fall. Mostly it looks like because on the I-140 form there is a certain box that you can check that isn't necessarily wrong, that like derivative applicants for the most part checked a certain box, and USCIS rejected a number of those applications. A number of those were probably also filed with I-140 downgrades because those were the people who were eligible to file in October or November of last year. So it wasn't because it was an I-140 downgrade. There were a number of those rejections by USCIS just based on how they interpreted the form. And then after January, when the new administration started, they took a look at those rejected I-485s and actually invited a number of those erroneously rejected I-485s to be resubmitted and assigned them the receipt date that they should have gotten, based on the October or November mailing. So there may have been a rejection based on that. Hopefully, if yours was one of those applications, you received an invitation letter from USCIS to resubmit it. And for the most part, we've seen those accepted and processed, or they're still pending, of course, but those have been accepted by USCIS.
The questions about the Telegram group that I was speaking about, the group that is involved in getting an appointment with Joey Lofgren, it's there at the show more thing. If you go down at the video, it will be there at the bottom. The Telegram group is there. So you can go ahead and join that group, because they're trying to make it as a group and go to Joey Lofgren. Keep following us, guys, and we're going to keep drafting. We have now seen that the State Department definitely is responding. Whether they responded in the way we wanted or not is different. At least we got a response that came out. We're going to. We are practicing lawyers, guys. We're not YouTubers. So we will give the links to you where you can draft, and we want actions to be done by you too. So we want you to write letter to the Congress people. We want you to write to the letters, emails to the State Department. If you think so you're getting affected, if you think so that you need to get some answers which we cannot provide, only they can provide, we're going to draft those things. We just will educate you, but it will be you guys to contact these congressmen. I want you guys to form groups in each of those cities. Try to contact the Indian organizations. They do have an outreach though. They do have connections with the congressmen and senators. Outreach to those people and reach to those people and have them use these Indian organizations, because these wastage of the green cards, almost 90% of them, if not more of them, would have only gone to Indians. Now, if we don't use these things, though, you may have to wait for maybe 20 plus years for you to get it. Now, if you miss these things, it will take, for the people who are applying right now, for the people who have not, priority date is not current, it may take decades. It may sound funny to you. Why would it take decades to move 1 year? Look into the statements made by Charlie. Yesterday, he said that it was only moving 2 days every month, at the most a week. It didn't move much. Let me tell you one thing. In 2012, in April of 2012, the priority date was May 1st, 2010. After that, it moved back. It never came back until 2021, April. So it took 9 years to come back to the same level. So if these extra green cards will not be given to the people who deserved, who's been waiting for a long period of time, it may not be 9 years anymore. It may be 20 years for you to get the green card. And while this is going on, I don't know how many people will be alive, how many people will be dead, how it's going to go, what if the main applicant dies? I don't know how, it's going to be very complicated for all these things. So it is better for you to act, be on alert, make sure that you write letters to the congressmen, take an active role, make sure your friends, family, and other people write letters, guide them out, show them the drafting of the letters. We have provided all these things for you. We cannot do it alone. You have to do it. We can only help you. We can only guide you. We can only take the horse to the water. You have to drink it.
Paul and his wife each have an H-1B approval and each have I-140 approvals that have priority dates that are within a month of each other, and is asking about filing separate I-485s based on each of their I-140 approvals when their dates become current. So you definitely could do that. It may not be necessary. You could just go with the person who has the slightly earlier priority date and file your whole family's I-485 applications based on that I-140. But there's nothing preventing you from filing another set of I-485 applications on the other spouse's I-140 approval. What you might be able to do is, if both of you have, or one or both of you are in EB2, the other one is in EB3, you could potentially file a set of I-485 applications based on the EB2 approval and another one based on an EB3 approval, just so you have kind of options in each category in case there is a change in the direction of the priority dates and EB2 moves forward faster than EB3 all of a sudden. And at a certain point, when one set of applications does get the final action date that's current and USCIS is ready to adjudicate it, what they usually do when you have more than one I-485 pending in more than one EB category or preference category is that they will send you a notice asking which application or which preference category you want to go with, and at that time you can just withdraw the other set of I-485 applications. So it may not be necessary, but there's not necessarily any harm in doing it, besides an extra set of I-485 filing fees.
Venkatesh from YouTube has this question. Unemployment benefits have been filed by somebody without my knowledge. My employer received a letter. Should we need to take any action from my side? Yes, you need to. Because this may be a identity theft. Somebody might have been trying to make money from unemployment benefits from yours. So you might want to immediately contact the State Department for the unemployment and mention that you did not apply, you had a job, and you provide them, write an affidavit, write a letter, send them in certified letter, send them in FedEx, make sure that you call those offices. You'll be very surprised though, this unemployment benefits office, they pick up the phones. Not like the USCIS, they do pick up the phone. So please contact them. They will take care of you. But make sure that you have record of what you're doing, just in case if tomorrow if somebody asks, hey, you're on H-1B, why did you apply the unemployment benefits? Then you can provide the evidence that somebody did it and you did not do it. And because these things sometimes reflect when we go to the 485 interview, they come to a point, hey, why? How come this guy applied for unemployment benefit? He's on H-1B, he applied for unemployment benefit. That will be a problem. So if you try to collect all the documents and keep it with you, you'll be in a good shape.
Ashish from Facebook is asking if we've seen any approvals of the EB2 to EB3 downgrades that were filed last October. So yes, we have. For the most part, I believe the approvals that we've seen so far are the ones that have been successfully upgraded to premium processing. I believe the majority of the I-140 downgrades filed last fall, if they're still in regular processing, as far as I know, most of them are still pending. But we have upgraded a number of them to premium processing, and we've gotten approvals also for a number of them. Sometimes there is an RFE for an ability to pay issue potentially, but Yeah, we've seen a number of approvals for those EB3 downgrades. If you are interested in upgrading it to premium processing, we do recommend it, especially as we said earlier, if you are considering to change employers and using AC21 to change employers. Just be aware that it could take a few tries to upgrade your I-140 to premium processing because they need to match up the original labor from your EB2 approval, which was several years ago. They have to pull it and transfer it to your EB3 file before they can put it in premium processing. And so sometimes you need to send in that I-907 and the $2,500 check a few times. If USCIS doesn't accept it, they'll just mail it back to you without cashing the check, wait maybe a week or so, and then try sending it in again.
Srikanth has a good question. Is the wastage going to be considerably worse than 100K or lesser? Well, if you look into Charlie's statements from before to right now, previously he said, I'm not going to dwell into the numbers. This time, he just said it's expected to be 100,000. That was for the August visa bulletin. We don't know when it comes to the September. We don't know when it's going to the October visa bulletin if he may change. Because based on how the things were going on, the numbers are increasing. So for that reason, I strongly still recommend you guys need to act. Otherwise, we are going to waste 20 plus years capturing the same thing coming in. A lot of people are asking about the pending legislations that are going on. There are a couple of different things that are pending, guys. One is that there is a Congresswoman Meng who amended into the USCIS appropriation bill, where it's preserving the family-based immigration excess not to fall into the employment-based and employment-based using within the same year. The way she amended is that it was for the year of 2000 and 2020 and 2021. That looks very strange to me because 2020 is already over on October 2020. So what is she trying to do? It's already fell down into the employment based, and we're already, hopefully so, we are using it. If the USCIS and State Department works properly, we'll be using it. So it looks like it may have a further technical amendment that may hinder the opportunity for the employment-based to get the 150,000 green cards, which Charlie has been telling all along is going to fall into the employment-based. So it's kind of good and bad because we would be able to retain the 120,000 that got in. We would not be able to get the 150,000. So we yet need to see how it's going to progress. At this point of time, I'm going to only give about 10% chance for this bill to go forward. There are other bills right now, the Citizenship Act, that the Democrats are trying to attach to the budget bill. But we have to see how the things progress in the budget bill. Will it be added to that into the budget bill or not? We have to see.
So Mani had their I-140 in process with one employer, then switched to another employer and is asking about their options now. So it depends a lot on what your first employer did or has done with that pending I-140. If they have withdrawn that I-140 and are no longer going to support the green card process for you, your main option is to basically restart the green card process with your new employer, have them start the perm from scratch, which unfortunately could take about a year from now based on Department of Labor's current processing times. If the previous employer has not withdrawn that I-140 petition, if they left it pending and it eventually gets approved and they are willing to have you rejoin the company at some point in the future, or at least keep that job offer open for you, and if your priority date does become current later this year, you could potentially have that company file the J supplement along with your I-485 application, basically having your previous employer be the one that supports your I-485 application if they are willing to file that J supplement for you, if they haven't withdrawn the I-140 and still have that job offer open for you.
What are the chances for every employment-based priority date to be current? That's our demand. I mean, if you're wasting the green cards, why can't you make it current? I mean, it's like they're wasting all the food. Why don't you give it to the beggars? That's what we are. I mean, why can't? And that's the pressure that you need to build. I think so. The main focal point of my effort would be to contact Congresswoman Joey Lofgren. That's the only lady, because she understands the process much better. She's been fighting to take the per country limit off. She's been fighting for a long period of time. And this, we don't need to go to Congress, which has its own problems in passing any legislation. This is just an administrative procedure that can be done. So now she is in the Judiciary Committee. She's, I think so, as chairman of the Judiciary Committee. She's in a very high position as compared to what she was in 2007, what she is right now. The Democrats are in power. She's in the Judiciary Committee. She has a good position. So that's where my focus is. She can make all the things current. That's one thing. There are other things what she can do is, as Rebecca was pointing out, the simple steps USCIS can do. USCIS can adjudicate all the green card applications, and they can revoke it later on. In that way, they can preserve the numbers. So that provision is there with the USCIS too. Either State Department can make everything current to put the pressure on the USCIS, or USCIS can make all the green cards approved, and they can make all conditional green cards approved. Hey, all the green cards are approved, but if you prove that you're a criminal or something like that, they can revoke the green card. Nothing. We don't want these criminals to get the green cards. So yeah, there are ways that we can still prevent this 100,000 green cards. And not only that, we have to make a base to make sure that not a single green card will be wasted in the coming year.
Sudashish from Facebook luckily had his EAD approved based on the pending I-485 application. And is asking about the options to switch jobs using that EAD. Yeah, so the benefit of that EAD is that you can change employers now without having to have an H-1 transfer or other non-immigrant petition filed. You no longer have to file an amendment every time you change work locations. For travel, it is so much easier. You don't need to make your way through the consulate to get visa renewals, go through the Dropbox. All these additional things. That is the benefit of having a pending I-485, even if it takes longer for the I-485 to actually be approved. That is why it's so important to let people file the I-485 and get that EAD so that they can have more flexibility while they remain in this years-long wait. So kind of along with what I mentioned earlier about AC-21, like I said, just keep that in mind. The 180 days, if your I-485 was filed last October, then you are eligible for it now to switch jobs based on AC-21. For people whose EAD is not yet approved, if you do want to use AC-21 to change jobs, you do need to keep in mind that if you're on H-1B status, you still need the new employer to file the H-1B transfer for you along with the I-485J supplement.
The question that came from Sri Nag is, does creating a petition online and submitting, is that a better way of requesting the GC holders and the US citizens to write a letter? Well, which is a better way? I think so. None of those things are a better things, though. The best thing is you personally writing, the person who's getting affected, personally writing. We have given a draft. We do encourage that you use the draft and write a personal letter, personalize it, or write your own, make your own letter though. The online petitions normally, I mean, people just go and click it on it. And that's not that, we don't think so that gives that much importance. But if you write letters to the congressman, it definitely makes a difference. You don't have to be a US citizen, you don't have to be a green card holder to write a letter to the congressman or the senator. Venkat TD from YouTube is pointing out that Charlie has clearly said that there is no chance of making it current like the way in 2007. You're right, but let's look into the analogy what he made. He said in 2007 July he did not have enough 485 applications there. Or what about it? We still don't have enough 485 applications there to be adjudicated in the next 1 year. We don't have enough 485 applications pending there. According to the USCIS website, it's only 268,000 green cards by March 31st of 2021. So they still don't have enough available 485 there. So if you go with the same analogy, yes, he can do it. He is not doing it. He's not willing to do it. Well, that's the reason I want to put a pressure from the Congress people, from the administration, to have him do it. Hey, why are you wasting the green cards? You're telling that it's going to be 6 months to 12 months. Where are you? Where is the State Department? Are you not looking at what the USCIS has been telling all along, that it's taking 50 months to adjudicate it? Well, we will tell that thing in the next thing. We will draft an email and we'll give it to Charlie to set it, but it may not be enough. We may have to put the pressure from the Congress people to have these things. I know last time, let me tell you one thing, Venkat, what Charlie did in July 2nd of 2007, though, he pulled back. What he told that he can find, he pulled back. But guess what we did? Joey Lofgren, from Congressman from San Jose, she put a pressure. How did you do it? How can you do that? She made the State Department change, and they were being forcefully told to accept the applications until August 16th of 2007. Even though he pulled it back, we are allowed to file. Even after July 2nd, we are allowed to file. Well, by the time the Congresswoman acted and the State Department have to react to that thing, from July 2nd to July 16th, we didn't file anything. We were just sitting idling, doing nothing and just answering the questions to the people. We don't know what was going on. We took the money and we filed the case. We don't know whether it's going to be accepted or not. On July 16th, they come and then say we are going to take all the applications. Not only that, they're going to take the application from July 16th all the way to August 16th. Did Charlie liked it? No. Did the USCIS liked it? No. Did they wanted it? No. But did it happen? Yes. So that's what we're trying to do by drafting all these letters. You are the person who is going to do it.
I saw a follow-up question about the rejected applications that were later accepted and what receipt date is considered assigned to them. So the receipt date should be the date that you originally tried to mail it the first time, so October, November last year, most likely, even if the time that you actually submitted it to get it accepted was March or April of this year. That was the time that USCIS got around to inviting the erroneously rejected applications to be resubmitted. So when you get the receipt notice, you should, and we have seen it on the accepted receipts, that they have printed the receipt date of October 27th, or whenever you initially tried to mail it to USCIS.
Neha is asking questions. She has filed on October 21st of 2020, still no biometrics. Priority date is March 2011. Please suggest me what can I do. Previously, I did told that they never took the biometrics from the previous applications, though. Today is the first confirmation that I got that they have taken biometrics from previous ones. So there is a possibility they can do it. They have done some, but not all. That's one of a case, but it was confirmed that without biometrics also they can. But at this point of time, there is no way, Neha, that we can force the USCIS to do the biometrics for you. Because if you contact the online, they say it's 50 months, you cannot contact us anymore until it is March of 2017, your application has been filed. You contact the congressman, same thing. You contact the ombudsman, same thing. So the letters that we drafted are not for your personal benefit, as a policy memo, as a policy that we want USCIS to change and we want the State Department to change. That's the letters that we drafted, not for your personal things though. The personal things are only we can do it after it crosses the timeline which they prescribed in Texas Service Center case. What they're telling is it's 50 months. 50 months is 4 years plus 2 months.
Samir is asking if he can continue working based on the pending EAD renewal if the EAD that he has is based on an I-485, so a pending GC EAD renewal. So in that case, you can work beyond the expiration date of your current EAD card if it was issued based on the pending I-485 while you are waiting for the renewed EAD to arrive. So that's a big difference from the H4 EAD or the L2 EAD, which is, everyone is aware, you cannot work based on the pending I-765 for an EAD based on H4 or L2. But for an EAD based on a pending I-485, you can work for up to 180 days beyond your current EAD expiration date as long as the I-765 is filed and pending.
Funny Kumar is asking this question from YouTube. Can you travel outside while I-140 is pending, not 485? If you are otherwise qualified because you're an H1, H4, L1, L2 visas though, and you have the passport stamping and you don't come under the ban, just because your I-140 is pending, if you are any of the H or L visas, you will not have any problem whatsoever at all in traveling. Any other things, Rebecca?
No, right now.
Thank you very much for tuning in. Make sure that you follow the directions we keep it. There is a lot of information that we provided at the bottom. If you want I-140 copy, you can get it. If you don't have a birth certificate, what are the alternative steps that you can do? Please go show more at the bottom. It has all the description that you have. The Telegram group of the San Jose area is also listed in there. If any of you guys are from that area, we strongly recommend that you become members of this organization. Thank you very much.